I don't think you can ever begin the term of finding the answer until you know the question.
Why is it that so many lawyers do sort of launch into answers without really expressly stating the question? And do you agree with me that they do that?
I think that frequently the issue is stated too broadly. Not quite this, but the appellate court was in error in deciding the way they decided. And once the issue is stated broadly, I think it becomes very difficult to have a well-structured answer, and you just invite rambling. So I do believe that to the extent that you are able to hone your question down, you at the same time are honing down your answer.
So an unfocused issue begets an unfocused answer.
Right. I would almost describe reading a brief as a search for the issue. And it's amazing how frequently you don't really find it until the second time through, if at all. What is it that we have to decide? If it's a statutory interpretation, what are the words that we have to deal with? If it's a constitutional issue, is how is this fact pattern a violation of the Constitution? As simple a question is whether it's a facial or as implied. And I do believe that the really fine writers are able to narrow the whole business down.
You have a couple of times now referred to issues and to questions, and I always think of issues as being questions, but it's amazing how many people think an issue can be an affirmative statement, the trial court erred in doing something. But isn't an issue in essence a question?
I believe that an issue is a question. I don't think it's open to debate.
Do you have the sense that there are a fair number of cases in which the lawyers don't really quite grasp the issues in their own case?
Yes.